Welcome to a live episode of Surviving the Survivor. We bring you the best guests in all of true crime. Don't forget to subscribe and smash that like button. Here's your host, Emmy Award-winning broadcaster, Joel Waldman.
What's up, SDS Nation, and welcome to a special live breaking news edition of Surviving the Survivor, the podcast that promises to bring you the very best guests in all of true crime. And yes, indeed, there is breaking news involving Sarah Boone. As you'll recall, she was convicted at the very end of October. If my memory serves me correctly, it was October 29th, a couple days before Halloween. Today is Election Day, November 5th. And already the attorney for Sarah Boone has filed a motion for a new trial. We're going to deconstruct that. And hopefully in a little while, Mark Najam, an Orlando-based attorney, will jump on. But if not, I'm going to break it all down for you and hopefully take your questions. So, again, the headline here is Sarah Boone wants a new trial. No surprise. As you'll recall, Sarah Boone had a plea deal. She rejected, and I'll discuss that a little later on. She would have been given time served, and then would have only had to serve roughly 8 years. Now we are awaiting sentencing on December 2nd, and the betting odds are that she's going to be serving a whole lot more time than 8 years. So, did she shoot herself in the foot by not taking that plea deal? Universally, defense attorneys who I've spoken to said 1,000% she should have taken that, but she did not. So now she's got to, as they say, make her own bed and sleep in it. And in this case, I guess you could say it's a cot. So again, the jury back on October 29th deliberated only 29 minutes. They've 90 minutes, not 29 minutes. They found her guilty of second-degree murder. That was the most severe of the charges. And this morning, suddenly a motion is filed in court. And essentially, it is broken into 5 parts. And it was written and signed by James Owen. As you'll recall, James Owen was Sarah Boone's 9th attorney. She had public defenders. James Owens was actually a private attorney who responded to Sarah Boone's request, crazy request, kind of a hand chicken scratch written request from her jail cell, seeking a new attorney after the judge had said to her, look, you've gone through so many attorneys, you are now going to have to defend yourself. You're going to have to do this alone, giving you enough chances. You've gone through 8 lawyers. You've fired them all. You've been antagonistic. You've been threatening. You've been, very, very degrading in terms of the language you're using to describe them. So no more chances for you. You are now going to defend yourself. And that's when she kind of in a fit of desperation put together this help wanted note from jail, which looked like a kindergartner did it. And lo and behold, an attorney from the Panhandle, credit to him, James Owens, a criminal defense attorney who I believe was at one point a public defender. He raised his hand and said, look, I will take this and I will defend her. He only had 45 days to prepare. So this morning, after having really gotten their butt handed to them, I guess, for lack of a better phrase, they filed a new motion saying, look, Sarah Boone deserves a new trial. They're citing Rule 3.60, which says clearly the defendant asserts that she's entitled to a new trial, and then listed the following grounds for that reason, saying that the court was wrong. The court was wrong in saying that Sarah Boone was not entitled to court-appointed counsel. So they're saying essentially it's her constitutional right to have a public defender. How dare Judge Michael Kranick say that's it? She's got to go it alone. So that is the first point in this motion. The court erred, they're saying as well, in denying James Owens multiple motions for continuance. They wanted to move ahead with the trial. The court said we got to move ahead with the trial. James Owens was looking for a continuance. It did not happen. It was slapped down. They're saying they deserve that continuance. Point 3, and then we'll break these all up. The court erred in failing to grant a new trial. So they're saying the court never granted a new trial when the alleged victim's family, that of course is Jorge Torres. I was in court when this happened. They're saying that when the alleged victim's family had an emotional outburst in open court, it affected jury deliberations. I can tell you, I was sitting in there at that time. The Torres family was coming and going in and out of court on periodic days. But for closing arguments, the family was seated there, including the mother. And when they got to the video, of George being zipped into the suitcase, pleading for his life, the mother, understandably, she just couldn't handle it. She said, look, I am unable to emotionally handle this. She didn't elucidate it in that way, but she just broke down crying. She doubled over, and her son had to escort her out. Well, shortly thereafter, James Owens got up, and he was really upset. And this became a point of antagonism between he and Will J., the prosecutor. Will J. said, look, I cannot control a victim's family. This happens in criminal court cases and other court cases. We are not here. The state is not here to control the family. James Owens said it muddied the waters. The jury was impacted by this. It's human emotion. What can you do? And I think the jurors, in my own opinion, they probably did hear it, but I don't think that was a big impact on their decision making in the deliberation room. The fourth point here, and then I like I said, we'll go back through these 5 points and break them down. The fourth point is the trial court failed to disallow the opinion testimony of the state's rebuttal witness. So as you'll recall, if you watched the trial, there was a woman named Dr. Tanya Werner. The defense called 2 expert witnesses, and then the state had 1 expert witness who was a forensic psychologist named Dr. Tanya Werner. And the defense is alleging that she changed her opinion while she was on the stand, different from what she gave when she was deposed earlier in October. I believe it was October 4th. This expert witness was deposed by the defense team, and basically they argued, and this all revolves around battered spouse syndrome, which is what the defense was trying to use in defending their client, Sarah Boone. But this expert witness, they are claiming, the defense is claiming, changed her basically assessment. She couldn't diagnose her, but changed her assessment of Sarah Boone, essentially saying, in this moment of time, in this 20-minute window where essentially Jorge Torres suffocated and lost his life, that in that moment in time, it was not indicative of what is commonly known now as battered spouse syndrome. And again, the defense says, how could this woman change her opinion midstream, meaning in the middle of this trial? So the final point here, and look, this is a defense attorney's job to throw as much at the wall and see what sticks. But the defense's final point: the state committed prosecutorial misconduct by essentially making a second closing argument. So what they're saying is, instead of a rebuttal statement, they had a full closing argument. And according to Florida law, you're supposed to be rebutting the points that the defense made in the state's rebuttal, but they're saying, look, they gave an entire new defense. They were reading, I believe, some text messages and other things in that rebuttal, and they said it was an overreach, prosecutorial overreach, to be doing that instead of just responding to the defense. So let's see here. I think the COE has argument 1 up that's kind of detailed and broken down a little bit more. I'm going to pull this up here. So this is argument number 1. The trial court erred, and I'm looking at my own notes here. The trial court erred in holding the defendant was not entitled to court-appointed counsel. Again, James Owens is her 9th attorney, and basically Judge Michael Kranick said there are no more chances for you. After the 8th attorney, you got to represent yourself. So in the above styled and numbered case, the defendant had approximately 7 court-appointed attorneys. I think it was 8, but they said 7 prior to the undersigned counsel taking her case. Undersigned counsel took on the above case because he was concerned that Ms. Boone would not have an attorney to represent her at trial. And this is true. This is what James Owens said. He actually said he heard about it or found out about the ad, Sarah Boone's ad on Court TV. But essentially, here, he's saying, James Owens is saying, look, I had to get involved because I'm a criminal defense attorney, and I wanted to make sure that she had a rigorous defense. So that is the point he's making, and goes on and says that the above case was very complex, even for a seasoned trial attorney who was the public defender. So you see there, James Owens was a public defender in the first judicial circuit for many years, as well as having a thriving private practice. It was apparent to undersigned trial counsel that Miss Boone would be grossly ill-prepared and unequipped to handle a trial in this matter, or in fact, to handle any other phase of the trial without counsel. And we're now joined here by Jessica Mashali to save the day, who, by the way, won her own case. I believe the woman's name is Marsha Thompson. Jessica defended her in a battered spouse case. She won. Jessica, first of all, thank you for hopping on short notice. Appreciate you being here.
Sure.
I know you're just finding out about this, but there was a motion filed with essentially 5 bullet points by James Owens, the defense attorney for Sarah Boone, stating why she now deserves a new trial. Just your broad-based reaction to hearing that.
So I just took a quick look on it right before I jumped on, and a motion for new trial is something that is standardly filed in every case unless the trial is a win and it's a not guilty. So it's part of standard practice. Every lawyer has to do it, and we kind of just put together the best things we can possibly think of that we want to bring to the court's attention. In the best case scenario, we're preparing the appellate lawyer for some of what we think are the most important points for the appeal. There's always an appeal, so there's no question she's going to be filing an appeal. And this is just kind of a step in the process. I don't see anything there that I think the court is going to take seriously. I don't think she's getting a new trial at this point. What will happen when her case is appealed is a different story.
Yeah, so you're hearing from Jessica. This is standard operating procedure, SOP here for defense attorneys. This first point, Super Kelly here saying Owens is just angry because he looked like a fool. Look, I think he's doing his job. I think he was emotionally invested in this. It says here, Jenny Allison, 7 court appointed. It was 8. Why does it say 7? I don't know. He's saying roughly 7, I think. He's saying approximately 7. But Jessica Mashali, this is argument number 1 by the defense. I have it up on the screen, which I know is tough for you to look at. But basically, he's saying the attorney is that Sarah Boone had approximately 7 court-appointed attorneys, and James Owens, took the case because he was personally concerned that Miss Boone would not have an attorney to represent her at trial. And so, he's kind of, I guess, virtue signaling a little bit, saying, look, I was the only one who was willing to come and defend her, but she really deserved better than this. On that particular point, what is your reaction to not being allowed to have court-appointed counsel after her 8th attorney?
No, that's a no-go. So, I was a public defender for many, many years, been in the courtrooms, and it is very common for defendants to want to get rid of their attorneys. And I think that the judges err super on the side of not allowing them. So they'll keep attorneys on who are, from what I can see, fully incompetent, right? And they'll say, this is enough. This is your lawyer. This is what you got. This judge, I think because it was so high profile, went out of his way to allow her to have repeated attorneys appointed at the cost to us, right, to taxpayers. And there was no evidence whatsoever that any of those attorneys were ineffective or doing anything wrong or not providing her competent counsel. So she was just unhappy. She got rid of them. She didn't want them. I don't think that there's any reason there that she would get a new trial. And I think this lawyer stepped up and decided to take her case. That was his choice. There are people who don't have high profile cases, who are indigent, who are poor, who come from nothing, who are getting really subpar representation every single day in this country. He took this case because it was high profile. He chose to take it. He chose to step in and do his best job. And it looks to me like he did a very good job.
Ida Shaw is pointing this out. This is true. I believe her first attorney was a privately hired or retained counsel. So 7 is the public defender and 1 private, and that's how we get to 8. And then James Owens is number 9. Jessica, in this motion that was filed this morning, James Owens specifically says Miss Boone's behavior did not rise to the level of misconduct to warrant a waiver of the right to court-appointed counsel. And if the court determines that she waived her right to court-appointed counsel, then the court failed to warn her or inform her that her continued misbehavior would result in a waiver. So he's saying 2 things here. He's saying she wasn't annoying enough, and if she was annoying enough, then the court didn't warn her. I mean, does this hold any water? That's question number 1. And what is legally the definition of being annoying or too annoying or disrupting the court in this sense?
So I think that this does not hold water. She can be as annoying as she wants. She's still entitled to her constitutional rights. She's still absolutely entitled to counsel. And if she's indigent and she can't afford counsel, she's entitled to court-appointed counsel. But she's not entitled to the court-appointed counsel of her choosing. That she's not entitled to. There is no right to that whatsoever. So the judge was appointing lawyers. She was choosing to fire them. In many cases, like I said, that I've seen, people don't even get that option once. They don't even get to say one time, no, I don't like this lawyer. I don't want this lawyer. They don't get that option. They ask the judge and the judge says, I'm sorry, this is the lawyer I've given you. This is who you're going to have unless you have the money to hire your own. So she was given that again and again and again and again and again. She's not entitled to choose her lawyer unless she can pay for that lawyer, or unless, like in this case, a lawyer wants to step up and represent her for free.
Okay. Point number 2, and if you're just joining us, there's a motion that is filed, a new motion from Sarah Boone's defense team, James Owens, essentially saying that she deserves a new trial, and there are 5 points that he lays out. The first point is that she deserved here to I'm looking for the exact wording so I don't screw it up, that the court erred in denying undersigned this is the second point. The court was wrong in saying Boone was not entitled to court appointed counsel. So basically saying that she was deserving of a public defender, which she did not get. So that was point number 1. Point number 2, Jessica Mishali, the court shall not deprive a defendant of his or her right to counsel of their own choice, and failure of the trial court to grant a continuance will result in a new trial. So here he's basically saying she didn't get to choose her own attorney, which I don't really get, because James Owens, responded to an ad. And this is the second point here. He responds to an ad. She hires him. But in this point 2 of the motion, basically he is arguing that there should have been a continuance, I guess, to get the ducks in a row. But it sounds like James Owens would have needed that more than her, but certainly she chose him. I don't fully understand this. What do you make of point 2 in this motion?
I also think that she did choose him, and she was extremely lucky that someone with his experience and someone with that caliber and that name as an attorney and that skill was willing to take her case on. She was very lucky. She definitely had the lawyer of her choosing. And with regard to a continuance, the case was 4 years old. You don't get continuances forever, not even when you do hire new lawyers. And I have seen many cases with people who strategically hire and fire lawyers to gain more continuances. It doesn't go on forever. In this particular case, I don't know if he filed for a continuance, when he asked for it, if his client wanted it, because remember, she was also kind of pushy about wanting to get to trial, right?
Mhm.
She didn't want to be waiting anymore. That was one of
Yeah.
her complaints. So if they properly moved for it, it would be something the court would have to absolutely consider, but not required to grant where a case is 4 years old.
Yeah, actually 4.5 years old. So it was around for quite a while. And I agree with Jessica. What is the point of a continuance? The defense willingly took this, albeit they didn't have a lot of time. And you see it right here. This is argument 2 from the motion. This gave counsel, meaning James Owens and his team, 45 days to prepare for a second-degree murder trial. It's interesting because he signs it, but it is now in the third person. He immediately and aggressively began to prepare for trial. Undersigned counsel did his best to prepare for trial by traveling to Orlando from Milton, which is in the Panhandle, on multiple occasions, both for meeting with Miss Boone and attending multiple hearings. Despite his best attempts to prepare for trial, it was impossible to adequately prepare for unforeseen issues arising during trial. What about this 45-day window? I mean, obviously it's very narrow. Jessica, in your case, with Marcia Thompson, I believe is her name, how long did you prepare for that case, just to give people an understanding compared to this 45-day timeline?
5 years. So I prepared for 5 years.
That's a little bit of a difference there. Yeah.
Yes, it is a bit of a difference, but I mean, I'll explain. I was hired on Marsha Thompson the day of her arrest. So I was with her from day one throughout. She never had another lawyer other than me, and I worked on it for that entire time. I will say that it was my opinion, and I brought this to court many times, that the state was the one trying to delay it, and I often tried to push it. We also had COVID in the middle, which really shut down jury trials for quite some time. There were no jury trials, so there were reasons why it would be delayed. But I would say that certainly 4 years or 4.5 years in normal circumstances is enough to prepare for a serious, complicated murder case.
Yeah. It seems like enough. In news, they give us 30 seconds to prepare to go on air. But yeah, 5 years compared to 45 days. I can see why James Owens is raising that issue with the court. But again, a lot of this was her own doing by firing all these attorneys, being antagonistic, the whole deal. Argument 3 here, Jessica Mishali. By the way, Jenny Allison here says he gave her the best chance she had with that defense. It was the defense she wanted. All of these arguments in this motion had nothing to do with why Sarah Boone was found guilty. State's evidence was. Good point. I agree with you so much. I agree with you there. Prior to jury deliberations, this is argument 3. The alleged victim's family members, and I was in court for this, Jessica, the alleged victim's family members began to audibly and visibly get upset and departed the courtroom. This was, I believe, in the state's closings when they played the video. This was the first time the mother had ever seen this. Jorge Torres' mother had ever seen this. She was sitting to my left in the gallery. She kind of doubled over in agony and grief. She sobbed. It was an audible sob. It wasn't over the top. It was a very heartfelt emotion. And the son escorted her out of the courtroom, and she said she didn't want to come back in. I think she ended up coming back in for the reading of the verdict. But, you could tell it was the first time she'd ever seen this. And this is her son literally losing his life inside of a zip suitcase. So prior to jury deliberations here, the alleged victim's family members began to audibly and visibly get upset and departed the courtroom. Undersigned counsel timely moved for a mistrial, requesting a new trial. The court did not give any curative instructions or address whether the outburst could adversely affect the jury's deliberations. Florida appellate courts have held that failure of the court to grant a curative instruction or a mistrial can result in the necessity of granting a new trial. It's a lot of legalese. I mean, James Owens blew a gasket after this, and him and Will J went at it. And basically, Will J, the state's attorney, said, we can't control family members. Jessica, I'm sure you've seen this as a criminal defense attorney where emotion plays a role. This is not something the state could have controlled. Is there any basis for this at all? And it's basically pointing the finger at the victim's mother here.
I definitely don't think that there is a basis for a mistrial here. Emotion in this sort of situation is really expected what I think would be more prejudicial would have been an outburst towards Sarah Boone, right? This was an outburst caused by the sadness and emotion of the fact that this man was killed, is dead. That's a fact. That was not something that Sarah Boone's team was saying didn't happen. Like, no, there was no killing. No, this man didn't die. No, he didn't die in a suitcase. Nothing like that. Those facts were agreed to, right? So the mother having any kind of emotion would really only be normal. I don't think it prejudices Sarah Boone in any way as the defendant in the case.
By the way, if you have questions, I don't know how much time Jessica has, but not a lot, but we'll take some questions. Coffee first. Is there a set amount of time, Jessica, that James Owens needs to now continue to represent or help Sarah Boone, or can he bow out at any time? I can tell you, I asked in the press conference. It's a little scrum afterwards. He said he would not represent her at an appeal, and this was kind of a one-time deal. But what is the answer to this specific question? Because obviously he just filed this motion for a new trial.
So he is not necessarily obligated. He has the right to do a motion to withdraw any time he wants. The typical process of what happens is once you lose a trial, you do file a motion for a new trial. Then you file a notice of appeal, and then somebody else takes over for appeal. She is entitled to a free lawyer for the appeal if she's indigent. So at the first level, which is called a direct appeal, you will have a free lawyer if you're indigent. And it only makes sense that he would not take it on. Doing the appeal, I always say, really should not be the lawyer who represented you at trial. You want a new pair of eyes to look at everything and see everything.
Yeah, well, obviously we're seeing that with Charlie Adelson is doing, his appellate attorney is doing his best to get Charlie a new trial. Argument 4 here, and you see from Debbie Gibby, by the way, Melody Farris's daughter, and that was the verdict that was read yesterday, cried and sobbed the entire closing and during other testimonies. So obviously, anyone who's watched trials long enough knows that emotions can be a part of it. Tracy's asking, this is interesting. We'll get to argument 4 in a moment. Sentencing is set, I believe, for December 2nd. This won't have an impact on that date. Will it, Jessica?
It shouldn't.
Okay, there you go. Sentencing should still happen. So here's argument 4. The trial court failed to disallow the opinion testimony of the state's rebuttal expert witness, Dr. Tanya Werner, MD. She's a forensic psychiatrist, and I was in the courtroom. This, if anything, out of these 5 points, maybe has some legs. I'm not saying this does, but if anything does, this might be it. It was very confusing inside the courtroom when she was giving her testimony because it seemed like she was going back and forth on an assessment, not a diagnosis, but she made the distinction that it was an assessment that was, she evaluated Sarah Boone as having battered spouse syndrome, but not exhibiting signs necessarily in that period of time when George died. So it was a little confusing, to say the least. But essentially, the defense said she changed her opinion from when she was deposed by the defense counsel back on October 4th. Jessica, hearing that, your thoughts?
If she truly changed her opinion, then that should have been something that was addressed by the court. They should have taken a break from court. They should have determined what that change was. And if there was a true change in the opinion and that was deemed to be important or relevant, then I think the defense should have been given time. That's really the only remedy they would have been given. And when I say time, when you're in the middle of trial, that could be a couple of hours, that can be one day. It's not usually going to be more than a day break when you have a jury who's waiting, but time to sort of delve into what this new thing was and why there was this change.
This issue, it says at the bottom here, argument 4 was discussed extensively in the expert witness's deposition taken on October 4th. 2024, the state committed prosecutorial misconduct by failing to disclose this new opinion as agreed in the deposition mentioned above. And Jenny Allison actually said in the chat that James Owens actually, during an interview, said that she helped the defense's case because she basically said, look, here's the comment. She basically said she does have BSS, but she she said that she wasn't exhibiting sort of signs of that in that window of time again. So Jenny Allison's comment, Dr. Warner ended up helping the defense, ! Owens even said that in an interview after the trial, now he's trying to say it hurt his case. This is what defense attorneys do. So that was argument number 4.
That's certainly what we do. I'll say this, that's the first time I'm seeing that, and I find it really interesting. In my case, one of the things we were upset with is that the judge ordered and would not allow our expert to comment on whether or not he believed Marsha Thompson believed she was at imminent risk at the moment of the incident. The reason being that it, quote unquote, invades the province of the jury. Only the jury can decide if she acted in self-defense, nobody else, right? And so here, there was a different ruling. This judge was allowing both sides' experts to actually opine, essentially, on whether or not Sarah Boone was defending herself.
That's interesting. So there's a 5th argument here, and then hopefully we'll have time to take a few questions. If you guys want to put in those triple Qs so I can see it easier. Argument 5 here. The prosecutor committed misconduct by using rebuttal argument to make a second closing argument, is essentially what they're saying. What are the rules here, Jessica Mashali? Because, state went first, the defense gave their closing, and then the state was allowed to give a rebuttal. And I'll be honest, it all kind of blurs together. But in the state's rebuttal, I do think that they either played some more video or audio. And so the defense, again, is essentially saying, look, this was a whole new second closing argument. What does the law say about that? What does the fine print say? What is the determining line of what is a rebuttal and what is a second closing argument?
So a rebuttal, so the state gets what we called a sandwich, right? The state has the sandwich, which drives us defense attorneys crazy because they get to start out, give their whole argument, then I get up with my argument, and then they get to finish it up, and I don't get to respond to anything they say in rebuttal. So the strategy, I think, on the state side, when you have a good state attorney who knows what they're doing, is they're going to leave their most poignant and most exciting comments for the end because I don't get to say anything about it when they're done. So that's what they do. Now, the fine print is that it has to be a rebuttal. What does that mean? It has to rebut or go to something that the defense got up and said. That's not really hard to do because the defense is getting up one time and they're going to talk about anything and everything that they think is important in this case in order to close this up for the jury the best that they can. So they're pretty much bringing up everything. There's nothing wrong with a state in its rebuttal playing any sort of evidence, video evidence or showing pictures. All of the evidence that's been put into evidence during the trial is fair game for both sides during their arguments. What the state can't do is bring up something that the defense never addressed during their closing argument, which again would be rare because the defense is bringing up everything. It's their only opportunity to talk.
Interesting question here, Laura Lee Logan. I wonder if Owens would have been more effective if he wasn't having to deal with the snacks motion, wardrobe, hair, and makeup. Jessica, how big a distraction do you think that was for him? She was obviously, there was a point in time where she requested 5 peppermints and a juice box and cookies. And look at this. When it rains, it pours. We are now being joined by Mark Najam, who is a very prominent Orlando criminal defense attorney. Mark, I'm going to come to you in 1 second. This is obviously breaking news. Sarah Boone looking for a new trial here, but Jessica, what about the snacks motions and all of this? That was that a huge distraction, do you think, to James Owens to try to do his job effectively? Jessica.
So even though it seems so silly, I would say it is a big distraction. It's a really big distraction because it's not just these motions. It's what we could all see was sort of her personality and what she was putting her lawyers through. And any person only has so many hours in a day, right? An attorney only has so many hours a day, so many hours to dedicate to your case. And when you take up a lot of that time with things that could be silly or that are unnecessary, you really take away from your defense. You take away that attorney's time to focus on real strategy and real theory and this attorney is new to the case, he has to go back and learn everything that's been done in 4 years by 7 or 8 different attorneys. It's a lot of work. And the distractions really worked against her.
Mm. Mark, I don't know. Have you had a chance to even look at the motion because it's kind of breaking news? Are you just jumping in cold right now, Mark?
No, I'm jumping in cold, and then we had trouble with our server getting on, so I apologize.
I'm going to sign off, Joel.
Okay, Jessica, thank you so much.
I'm going to sign off, Joel.
Appreciate Jessica. Thank you for being here. I really appreciate it. So Mark, just before we get into some of the details, and I'll take you through it real quickly because you'll give us a different perspective. Again, Mark is one of the more prominent criminal defense attorneys out of the Orlando area, but and this is breaking news. Sarah Boone now requesting a new trial. Just that statement, Mark Najam. Jessica Mishali was saying that this is standard operating procedure. The defense attorney basically has to file this motion requesting a new trial. I'll go get into the points after this, but is there any surprise here from you at all?
No, she actually has to do it. If you don't do it, then you don't preserve it, and then you lose all ability on appeal or otherwise. So I'm sorry, someone's calling us. I'm talking to you. The fact is that it's standard. It's done in almost really every case. So it's really nothing. It's a nothing burger.
Okay.
Now, if the grounds are valid, great. But the fact is that you ask for a new trial, it ends up being heard by the judge. It's almost always they're denied. I mean, I don't have the actual statistics, but if I said 99% are denied, I'm being generous.
Wow. Okay. So let's go through these. I mean, we just kind of went through them, but we'll do it quickly with you just so you know what we're talking about. And then maybe we'll take some questions on the back end. And again, I appreciate Mark being here. This was argument 1 in the motion filed today, that the trial court erred in holding the defendant was not entitled to court-appointed counsel. So the first attorney was a private attorney. She then has 7 public defenders. She fires all of them. She's antagonistic. She's writing, notes. She's, badgering them and telling the court how ineffective they are. So finally, the court says, look, you've got to defend yourself. This is it. You've reached the end of the line. And now when that happened, she puts together literally a hand-scribbled note that Court TV picks up. This lawyer in the Panhandle sees it, named James Owens, and he says, okay, I'll defend her. But now this guy who defended her, James Owens, is saying she had the right to a public defender. What do you think here, Mark?
It's novel. I mean, I've done this for 4 decades, and the reality of it is I've never seen anybody. We talked about it in another show that we did with each other, and that I've never seen anybody go through 9 lawyers. 2, 3, maybe even 4, but 9 is, at what point ad infinitum do you allow somebody to really go endlessly? And so at some point, I think the court opined that it was her actions and not the attorney's actions. I know some of the lawyers that she went through, a couple of them at least, and she had excellent lawyers. And so at some point, if all you're doing is creating a situation by your difficult personality and your difficult, demands, then at some point there has to be an end. This will be likely a case of first impression for the appellate court. I'm unfamiliar if there are other cases that would suggest somebody having this much. Yes, you're entitled to court-appointed counsel if you're in fact you're indigent. Yes, you should be. And yes, you have to have effective assistance of counsel. But at what point, if you continue to take advantage of the system and you go through, I think she was on her ultimately 9th attorney. I think she hired one, had 7 public defenders, court-appointed attorneys. And I also want to say that thing. I'm not sure they were all public defenders. We have a system, whereas if somebody has a conflict with another individual, then they have court-appointed attorneys. Those are lawyers who go on a list, or they're in a certain state provided financed group that allows somebody to get counsel. So if you keep on knocking them out, you kind of run out of lawyers. And so it's going to be an interesting issue. I don't think it's going to hold water, because I think a lot of this was her own doing, and the appellate court's going to say she caused this issue. But we'll see how it plays out. But they have to make the argument. Without the argument, then they can't appeal it. So they got to make the argument and preserve it for down the line.
Gotcha. Deer in the headlights here. What about the judge? This is true at every turn. He would ask her, "Are you happy with the defense?" And it wasn't even a simple yes. It was like a declarative yes. They're excellent type of response here. Argument two. The court erred in failing to grant defendants' motions for continuance made by undersigned trial counsel. This gave counsel, you see it in the bold lettering at the bottom here. This gave counsel 45 days to prepare for a second-degree murder trial. He immediately and aggressively began to prepare for trial. Undersigned counsel did his best to prepare for trial by traveling to Orlando from Milton and the Panhandle on multiple occasions, including for hearings. Look, Mark, we just had Jessica Mashali on. She tried and won a battered spouse case. She said she took 5 years to prepare the case. She was with the defendant from the moment the defendant was arrested through the reading of the not guilty verdict. But here, this guy had 45 days. She had, again, been through all these attorneys, and he responded to an ad and willingly took the case, knowing when it was going to start, as did Sarah Boone. So what about argument two here? Obviously, it's a lot less, 45 days, a whole lot less than 5 years, but he knew what he was getting into, and so did she.
Well, you just handled both sides of the appellate argument beautifully. You covered both of them. And those are the arguments. The lawyer, it's going to be alleged by the state that the lawyer knowingly came on, and he or she, if a woman had taken it, knew and should have known that there was no guarantees of a continuance, and they took it under those conditions. The flip side is the lawyer is absolutely right to get ready for a case of this magnitude, particularly with a client of this difficulty. It's beyond a Herculean effort to have done so. This poor lawyer, I feel bad for him. I don't know him, but it was damned if he did, damned if he didn't. You know, the poor guy's coming down from the Panhandle. We're in Central Florida. For those listeners who don't know the state, it's a long state, and they're up in, he's up in the northern part of the state. We're in the middle of the state, and it is an ugly, long drive. And so this guy's having to go back and forth with an incredibly difficult client by every account, and try this case and get ready. So it's just, and this poor guy says, well, I'm going to go ahead and do justice, or I'm going to get my name in the paper by a big case or whatever it is. But it's like, be careful what you pray for. You just might get it. He got stuck with this case, and you hit both sides of the argument. He knew or should have known what he was getting into, but on the other side, she is entitled to effective assistance of counsel. And how can you get effective assistance of counsel in 45 days?
Yeah, exactly. Kova says, I hate this. She really thinks she deserves this. I'm sure she does. I don't know why she didn't take that plea deal. It's absolutely just ludicrous to me. Here's another question, Mark, before we get to argument 3 in this motion of 5 arguments. From Rosemary Romero outside Toronto, if Sarah Boone had represented herself pro se, would the appeal process be any different than if she had a lawyer represent her? That's a great question. What about that, Mark?
No. As a pro se, the worst people to go against are pro se clients. That was an excellent question somebody offered. They don't know the rules of evidence. They don't know the court procedures. They don't know what's going on. And you want, and it's a delicate balance when you're up against a pro se defendant or opponent. And the reason is that you can look like you're beating them up by, taking advantage and making every objection and keeping things out of evidence. And on the other hand, they're endlessly frustrating typically for the system. So you've got to find that balance of not of being respectful and not look like you're pounding them because you've got a law degree and they don't. But on the other hand, doing your best to maintain some measure of order and everything else. So the rules of evidence are still the same. The law is still the same. It's just that it requires a different strategy when your opponent is a pro se opponent. I will tell you that rarely do pro se litigants come out ahead. It's the old adage of, the fool has himself as a lawyer. So don't do it. Once in a while it plays out. Once in a while all things play out, but that rarely does.
Argument 3 here, and this to me is, in my opinion, kind of the most absurd of the bunch. But prior to jury deliberations, this was during closings. Mark and I was in there. The state played the actual suitcase video of George crying out for help, and his mother was in the gallery in the front row behind the state. It was the first time she'd ever seen the video. She broke down crying and was summarily ushered out of there by her son and remained out where she was sobbing outside. You couldn't hear her outside, but it says here, prior to jury deliberations, the alleged victim's family members began to audibly and visibly, it was one member, and visibly get upset and depart the courtroom. Undersigned counsel timely moved for a mistrial, requesting a new trial. The court did not give any curative instructions. On it goes here. I mean, Mark, you've been doing this 40 years. People get upset. These are horrific crimes that families are, either witnessing on video for the first time or seeing autopsy photos. This seems to me to be par for the course. What say you?
Yeah, once again, you're covering some very important points. The lawyer is doing everything right by bringing these issues up for new trial. And the reason is you've got to preserve them for purposes of appeal. Not actually witnessing what is described as an outburst. It's hard to say. There's a difference of crying and drying your tears and whimpering a little bit, standing up, screaming and cursing and pointing at somebody saying, "You're a murderer, you killed my child." Those are both outbursts, but they fall in different different points of the spectrum. I think the judge would have been better off by giving a curative instruction, by just simply saying that, this is based on the facts and it's not to be based on emotion. And because they are emotional. And despite what anybody says, both sides are always going to play to the emotion of a jury. Juries are not computers. Everybody wants to pretend that they are, but they're living, thinking, breathing individuals who are going to be making decisions. And although they're supposed to only follow the law, we all know as human beings that they're often going to get emotional. So it sounds like this outburst, as it was described, is nothing more than a mother crying over seeing her son being killed on a video, which is very reasonable. It doesn't sound like she got up and started screaming and had to be escorted out of the court by court deputies or anything. That would be a different question, a different scenario. However, I think the judge would have been in a better position if it was that much of an outburst. I mean, the lawyer is going to use the very flowery, prejudicial terms by describing it as an outburst, when in fact it might have been a comment or an act, but not seeing it. None of us actually seeing that. Can't really speak to it. But the judge is always going to be better off by giving a curative instruction, and then claiming that it was not so prejudicial that it would have so influenced the jury.
Here's argument 4. We'll move through these two. We'll take a couple of quick questions and we'll wrap it up again. Being joined by Mark Najam, a very prominent criminal defense attorney out of the Orlando area, on a day where there's breaking news in the Sarah Boone trial, a motion filed by her defense team for a new trial. Here's argument 4. This, to me, and I said this to Jessica Mashali, I think might hold the most water. This was very confusing when it was going on in the courtroom. The argument reads as follows: the trial court failed to disallow the opinion testimony of the state's rebuttal expert witness, Dr. Tanya Warner, MD, after the state failed to disclose before the trial that the witness had formed a new opinion relating to whether the defendant perceived an imminent threat at the time of the offense. So just to break this down for everybody, this was very confusing in the courtroom. Basically, she said, this is a forensic psychiatrist, a medical doctor. The defense had 2 psychologists, but this is now a medical doctor for the state. And she was basically brought on to say that she did not really exhibit signs of battered spouse syndrome. Of course, that was the entire defense's claim, that she was a victim of battered spouse syndrome. And basically what this psychiatrist said was, yeah, she does have battered spouse syndrome, which was a big win for the defense, actually. But she did not exhibit any sort of attributes of BSS at the time that this death occurred. How you come to that conclusion, I'm not really sure, but it was confusing in the courtroom, and this was a real point of contention. There was many in this trial, but this is where James Owens and Will J., the prosecutor, got into it in front of the judge. The judge ruled on it at the time, but now the defense is coming back and saying she was a problem witness. Mark, what do you do about that after the fact here?
Well, Will J, I know, known for many years, a very, very excellent prosecutor, understands the law, is a homicide expert. I couldn't even tell you how many cases he's likely had. Of course, we've been against him. He also was on the other side. He left the state for a while, came on as a defense, and is really amongst their very top attorneys there. With that said, I'm somewhat familiar with this particular issue, and it's an interesting one to go into your query. Again, another astute observation. What happened here is that the expert said, yes, Ms. Boone suffered from
Battered spouse.
Battered spouse syndrome. I'll analogize it to PTSD. You might have PTSD, but that doesn't mean that something triggered you. So the fact is you could have been in the military and you could have PTSD, but then something else happened and you committed a crime. Well, you have PTSD, but your PTSD wasn't triggered and did not cause you, or was not an impetus to have you commit that crime. So somewhat analogous here, we have a situation where the doctor said, yes, there was a dysfunctional, violent relationship between the two. She was a battered spouse, but in fact, that was not a trigger to this. That would have been the defense's best defense. She had PTSD. This is one person's opinion. I'm sorry, battered spouse syndrome. It was one person's opinion that this did not trigger it, but we know that she had it, and hence this is what caused her to act this way. That will be the best argument, that there was a change of opinion. In Florida, we have very liberal discovery rules. Under Rule 3.220, each side is required to provide to the other all discovery, and pretty much all discovery. So there's no gotchas, there's no surprises. Both have the opportunity to review everything and then make their motions, make their arguments, and make their evaluations of a case. The defense appropriately once again brought it out because it's not otherwise preserved, and said that because there was a change of the opinion, that they should have had enough warnings so that they could have properly done further, brought in their own expert or addressed it even more deeply. So that's kind of it. So that's a point of appeal. Remember, appeal don't dispute facts; they dispute the law. Did the judge make a legal error in the judge's ruling? You don't go on appeal and say, well, the facts are different. No, the facts are the facts. You're appealing points of law, not the facts themselves.
That's an interesting distinction. You are appealing the law, not the facts. Debbie Gibby here. I honestly think the video spoke for itself. In Sarah's own words, came back to haunt her, and they said they had a great day. They did. She said that numerous times. Doing 4-year-old activities, puzzles, painting, and hide and seek. Not things 40-year-olds do. Generally, this is true. And by the way, to Mark's point, that is exactly the argument Will J. made in court. He made the PTSD analogy, saying that she wasn't, using that as an analogy, that she wasn't triggered. And I'm pretty sure that is what the expert witness was saying as well. This brings us to the, hang on one sec. Does Mark know if the same prosecution team, this is a different county, so I don't think so, but they're interested in I don't know if you're familiar with the Maddie Soto case out of Orlando, Mark. It's a 13-year-old girl who is now alleged to have been killed by her mother's boyfriend. Yeah, but a boyfriend. Yeah. Right. So, but that I believe is in Osceola County. So it would be a whole different.
Well, respectfully, not necessarily. Our circuit is Orange and Osceola County. Okay. We're in Orlando, and Disney World is in Osceola County, and that's the same judicial circuit. So our judges, although they will rotate, and one might be in Orange and one might be in Osceola, the voters vote for a state attorney who oversees both counties, and the judges are under that circuit.
Yeah, and at one point, someone said that Will J. might be the state prosecutor. I do not know. I have to follow that up. But Stefan Stearns is set to go on trial in early 2025.
Yeah, let me say it's entirely possible. We do have an election today, and we have Andrew Bain against Monique Worrell, and there's been a lot of controversy with that. So who knows where all that will land and who will be in that office, next year. But there is a homicide team, and there's some great lawyers who are in there who are very experienced lawyers, and they specialize in criminal. In fact, I've got a partner joining me who used to be with them, and we just cut a deal over the weekend, and he's had 145 murder cases and 45 trials, homicide trials. So when you get to that level of some of these experienced prosecutors, they're very few and far between, but they're quite excellent what they do, and it usually takes a lot of years of experience to get to that number. So I don't know who will be on that case, but a lot of changes going on right now. We'll see what happens with the election.
IGG, hope this show never ends. I have to go run more errands out in the blowing snowstorm. IGG, where do you live? Because wherever you live, I'm glad I don't live there. This is why I moved to Miami. No offense, I'm sure it's beautiful, but I'm not a big fan of snow unless I'm going for a few days. Fifth and final argument here, then a couple more things, quick things, and we'll wrap it up. Argument 5, again, if you're just joining us, the defense, Sarah Boone's defense, filing a motion today asking for a new trial. The prosecutor committed misconduct by using rebuttal argument to make a second closing argument. I was in the courtroom, Mark, and I asked Jessica this. In the rebuttal, I think that they did play perhaps a new couple of text message or maybe a cell phone video. I'm not exactly, I don't remember exactly, but where do you delineate between a rebuttal and a second closing argument? And I assume that the judge would have been aware of this too and would have jumped in, which did not happen at any point.
Well, if they didn't make the objection when that was occurring, then they waived it. You have to object in order to preserve your issue for appeal. And you can kind of look at rebuttal the same way you would look at redirect examination or recross examination. It's an inverted pyramid. You start here as your direct examination, and then the other side can go ahead and cross based on that. Then if there's redirect, it narrows down so that, again, it's just an inverted pyramid. So if new information was brought up that was over and above what was first brought out in the actual argument, yeah, you can make an argument for it, but is it prejudicial? And they're going to say it was rebuttal, but they're just going to say it was a continuation. There's usually a way you can loop it in and show some measure of relevancy. It would be hard, it would be impossible pretty much if they never objected when that argument was being made, then it was arguably waived. If they did make the argument, it was probably not going to be prejudicial to a case because all that closing arguments are arguments. They're not facts and evidence. They're your opinion, interpretation of the facts that have been presented to the court, to the jury, through the course of the trial. So yeah, that doesn't sound like a very strong argument. But again, you can't fault the attorney because the attorney, without making the objection, it's not preserved for appellate purposes.
Interesting.
Thank you, Lee T, for saying it was informative and clearly explained.
Yeah. Mark could definitely be a professor. Speaking of that, we've got the Professor Joe Patuto coming on at 5, and famed Tallahassee defense attorney R. Timothy Jansen. He's coming on at 5. They're just going to basically take STS Nation's questions on the latest with the Dan Markel / Adelson story that never seems to end. And now her trials, Don Adelson's, has been continued to sometime late next year, probably summer or fall of next year. By the way, she's now on attorneys 4 and 5. So she's given Sarah Boone a little run for her money. I have 2 questions, Mark, for you. 3 questions. First is, what does Judge Michael Kranick do with this now that this has been filed? What is the judge's role here?
It's still, once these are done, then the notices of appeal are going to be filed, and they're almost guaranteed. So with that said, the judge will entertain these motions, which is routine, and then that's really it. And then once that, if there, well, let me restate that. If in fact there is a motion granted, and you have a new trial, It's unlikely from what I know and what I understand, but the judge will likely give some informed opinion as to why these motions would be denied, and then they would go up. You have to file a notice of appeal, and they would do that, and then there will be likely a new review done by the appellate court. Now, somebody just raised it. It's a very good point. She's not yet been sentenced. You don't get sentenced, and you don't get the appeal until after the sentencing, because you don't know what you're appealing. So they're asking for a new trial. That'll get presumably denied. The case has been set for sentencing. After the sentencing, all these will be thrown into the issues for appeal.
There you go. And I believe sentencing is on December 2nd. We will take that live. Hopefully Mark will come back at that point. So what about Will J., your friend Will J.? Does he need to do anything? Does he just look at this motion and shake his head this morning while he's sitting in his office? Or, I mean, what is the state's role here?
Yeah, he'll probably watch this broadcast, find a way or two to criticize me for my interpretation of things. But no, he's pretty much done. I mean, he'll file a response though to the motion for new trial, and then he will appear at sentencing and asking for whatever sentence that, likely life, but it might be less. They'll do a background check on Miss Boone with a pre-sentence report. That'll be presented to the judge, and that'll be so the judge will have more background information. Will J. will make his argument before the court for whatever sentence deemed to be appropriate. He would deem appropriate. The defense attorney will do the same thing, and then the judge will enter a sentence, and then from there the appellate, if she can't afford a private attorney her trial attorney will not be required to handle her appeal. He will file the necessary paperwork to get the appeal preserved within the timely fashion, and then it will likely be turned over to a public defender, appellate lawyer, unless you got counsel to handle it.
Yeah. So there was kind of at the end, there was kind of a tense moment between the media and James Owens, because there was a motion filed by the state, by Will J., essentially saying that they found out that there was some kind of odd arrangement for payment here. Just wanted to get your opinion on this. So there was an allegation by the state, which I then talked to James Owens, said it was categorically false, that he was being paid with like the rights to Sarah Boone's book because she's indigent. Now, it was a team of 3 attorneys, a jury consultant, and kind of a younger attorney who was acting more as kind of, I guess, in a paralegal type role. They did say that, I'm sorry, a private investigator as well, but they said that the private investigator was being paid by Sarah Boone. The issue here, Mark, is she's indigent. So essentially she's paying for this guy with taxpayer money. Is that a problem? I mean, how does that happen? Obviously she ran out of public defenders, but now you come to find out, this is what the state said, that she's essentially paying this private investigator, the only one who got paid in money, basically with money that was welfare money, essentially.
Well, it becomes really challenging. In all honesty, I apologize. You're limited to if you're indigent, then you go in and the state pays for your expenses. Everybody's entitled to counsel. The issue, though, is that when you have, you might not want the other side to know who you're hiring. And although you have to still put in your expert reports, you don't really know, you really don't necessarily want them to know right up front what you're doing and such. So there's a big difference of funding an attorney through a multi-day trial, coming in from out of town, and maybe paying $1,000 or $2,000 to a private investigator that maybe family paid for, or you sold a few assets or something like that. So you could be indigent, but not be able to afford, all your defense. I mean, a case like this could cost tens of thousands of dollars to 6 figures. And so, if you've got $2,000 or $5,000 you can put together for an investigator, that's a lot different than saying, you're funding it, but you're still getting public defender money. I don't fault anybody for that, as long as if there was a disclosure requirement, as long as you didn't try to sneak something by the court. But if you can afford something a little bit, then that's pretty reasonable, actually. You're going to want to get your best defense. But if you've got $2,000 or $5,000, you can get an investigator, but you can't get a lawyer. Then get the investigator and then have the public defender.
Lisa Peterson, he said, meaning James Owens, said Sarah owes me. I don't remember hearing that. Well, what does she owe? He took the case. That's on him for taking the case. Final quote here. I'm going to read your lawyer friend Denise, member for 8 months, still hear it every time. Lil J, that would be his rap name, I guess, for Will J. By the way, I miss giving Will J sock updates. A guy wears very colorful socks every day, and I was giving a sock update, but we'll try to get a lead on that for the sentencing on December 2nd. Final quote here. This was James Owens about why Sarah Boone did not take a plea deal. This was after the trial. Mark, please tell Will J his sock game is great. So next time you see him, please let him know. I told him that as well, but he's not a big fan of the media. He runs away from us. So
no, Will is not going to win any Mr. Congeniality awards for the media. So that's probably his little disco dance, just to be able to have a pair of socks that gives him a little bit more. Will is a straight arrow. He's an Eagle Scout. And he's not gonna, you're not gonna start tickling him and messing up his hair. But he's an excellent person, excellent lawyer.
Yeah, he ran away from us. So final quote here. This is what James Owens said about why Sarah Boone did not take a plea deal after this little media scrum after the reading of the verdict. And the quote goes as follows. Obviously, she felt like she didn't intend to kill George. That was just circumstance because they were both intoxicated. Things happened. That it was just really unintentional acts. And I think she felt bad about any kind of a murder conviction or pleading to any kind of a murder, that she was somehow criminally responsible for George's death. And I think that's where her mindset was. I mean, this is a good job by a defense attorney kind of rationalizing for his client, but she's kind of out of her mind here, in my opinion, Mark, for not taking a plea deal where she would have basically walked in 8 years or less. How fatal a mistake was that? She could be serving a lot of time here.
Well, if she'd won, she made the right decision. And since she lost, she made the wrong decision. So it's very easy to evaluate it after the fact. I think everybody who knows the system and knew this case that I'm aware of believe that she should have taken the deal. But you've got to do what your client wants to do. All you can do is your best, and you explain everything. If I may, though, one of your clients, one of your viewers had written that they thought that the lawyer was unprofessional and all. I didn't watch him, so I can't really speak to that. I will say, though, that as a defense lawyer, and we started off as a defense lawyer, we've done trillion high-profile crimes and cases and such around the country with a variety of things. I'm going to stick up for the defense lawyer in a big way without even knowing him. We are in a country, particularly on this election day, and I'm not going to get too much on a soapbox, but we are preservers of people's civil liberties. There are a lot of innocent people who've been convicted, and there's a lot of people who would have otherwise been convicted but for a defense lawyer. We're there to simply give one side. Remember, the state has prosecutors, law enforcement, endless money for investigators and everything else. And so the reality of it is you are going against the state. You're going against the government, where you've got somebody who are often, the underbelly of society, or they're the ones that are being, just completely destroyed by the press and otherwise. And we need that. So when people are taking shots at defense lawyers for representing, people accused of terrible things, don't align the lawyer to that. And, that's no different than, if hypothetically there's a law enforcement officer who did something bad. Well, they get their lawyers. They've got their fraternal order of police. They've got everything there too. They deserve all that. We don't really know. And it's an imperfect system, but as it sounds cliche, but it's the best one in the world. And we simply need to understand that people are entitled to a defense. They're not entitled to sleazy, lying lawyers as defenders, but they are entitled to lawyers who are upholding the Constitution or following the rules of the court. and making sure that somebody before the state imprisons them or kills them or takes away their liberties has gotten their side of the story out. So that viewer gave me an opportunity to say that. So you didn't shut me up. So thank you both.
No, I think that's incredibly important. Criminal defense attorneys, people love to hate on them, as the kids say, but they do one of the most important jobs. You never know when you're going to need a criminal defense attorney. It could be something you just get yourself into accidentally. Case in point, probably 4 or 5 months ago, I'm driving with my kids and some crazy woman just runs out in the middle of the street. If I hit her, maybe I would have been charged criminally. I would have had to call someone like a Mark Nijam, and you need these people. And he's just doing his job. So I'm glad that Mark did make that point. Again, look at this. Mark Nijam is a force to be reckoned with. I know firsthand, coming from Mossberg mom, who's in Orlando, in the Orlando area. We're going to be back today at 5 o'clock, kind of open-ended questions and Tim's take on the latest with Donna Adelson and Charlie Adelson. Lee T, I appreciate Mark's viewpoint, respect for the Constitution and justice system. Today is election day in America. Wow. I can't imagine what it's going to be like on these cable news outlets at around 10 o'clock tonight. But I will definitely be watching because I'm a news junkie, and I might be hiding in my bunker at an undisclosed location. I don't know. We'll see.
I might be calling my therapist, so we'll see what happens. So
bunker therapist.
I've got an 18-year-old daughter who's voting for the first time, and she sent in her mail-in ballot from London, where she's going to school. And my 17-year-old daughter is too young to vote, but she is bilingual, so she's at the polls helping translate. So her mother's taking pictures of her. So we're hoping for good things.
It is the American way. Last night, I tortured my 10, 8, and 5-year-old with a lecture about the Electoral College, and it's not necessarily the popular vote. They had no idea what I was talking about, but I tried to explain it. And there you go. Somehow I become. I put my
prediction. I put my Electoral College prediction on my Facebook today.
You did? Okay.
Yeah. So
is it your name? Is it just your on Facebook?
Well, I have Nijam Law, which we don't spend much time with, although we're getting ready to. Then there's a Mark Nijam, which is kind of a fan page, and then there's Mark E. Nijam, which is my personal one, but that's kind of all filled up. But yeah, we're getting ready to get started with it a lot more. We've now brought on some new people and kind of entering a new chapter with one daughter in college and the next one going next year. It's time to, a new thing's happening. I'm a girl dad, so
yeah, there you go.
Yeah.
I love it. All right, everybody. Love you, America. Love you, Orlando. Justice for Jorge Torres here, and we will see you at 5 p.m. A big thanks to Jessica Mashali and Mark Nijam. See you all.
Nice to see you.
Take care. Thanks, Mark. Thank you.